Welcome, curious minds, to another deep dive. Close your eyes for a moment and picture this. Ancient Constantinople, a city just buzzing with life. Legal scholars, imperial advisors, and just the sheer weight of centuries of accumulated laws.
Hmm.
Imagine the Emperor Justinian on his throne, not just ruling an empire, but conceiving something truly transformative, a project to untangle nearly a millennium of legal chaos and redefine the very fabric of Roman society.
It's a vivid image, definitely. And it perfectly sets the stage for what we're about to explore today, the Codex of Justinian.
Right.
This wasn't merely, a dusty collection of ancient imperial edicts. It was a revolutionary, incredibly ambitious undertaking. It was designed to consolidate and clarify Roman law, driven by this profound desire for order and unity across his vast empire.
Exactly. Its historical and legal impact is truly immense. We're talking about a monumental work that laid the bedrock for many, many modern legal systems, shaping Western civilization in ways we often don't even fully grasp.
That's so true.
So, our mission today is to give you a shortcut, essentially, to being deeply informed about this foundational text. We're going to extract the most important nuggets of knowledge from the sources you've shared, uncovering surprising facts and the foundational thinking that drove its very existence, all without overwhelming you with, dry details.
Think of this as getting, board exam caliber depth, but presented with our usual engaging, authoritative, and thought-provoking style. Our goal is for you to have some real aha moments about the origins of law as we know it.
Okay, so how will we navigate this complex legal journey? Where do we start?
Well, we'll start by delving into Justinian's initial, incredibly ambitious vision for the Codex and the, frankly, extraordinary team he assembled to bring it to life.
Okay.
Then we'll explore the layers of legal history that influence its creation. That includes the fascinating and often overlooked human element in imperial lawmaking, and how the actual legal texts were transformed.
Right, how they actually did the work.
Exactly. After that, we'll trace the Codex's turbulent journey through centuries of European history, from its supposed loss.
The whole Dark Ages idea.
Right, that whole narrative, to its dramatic medieval revivification and the rise of the influential Bologna school.
Ah, yes, Bologna.
And finally, and this is crucial, we'll dive into the actual laws themselves. We'll uncover the core legal and even theological principles that defined Roman societal order.
So we're really unpacking the essence of Roman law as Justinian saw it.
That's the plan. Get ready to truly unpack the very essence of Roman law as envisioned by a powerful emperor.
Let's begin by really unpacking this grand vision then. What was the legal landscape like before Justinian stepped onto the scene? What specific problem was he trying to solve with such an ambitious project?
Okay, so imagine a legal system truly drowning in its own history.
Yeah.
Seriously. Before Justinian, the Roman legal landscape was just characterized by an overwhelming complexity of the law and the length of litigation.
Sounds exhausting.
It was. And this wasn't just an inconvenience for ordinary citizens. It was slowing down the entire machinery of the empire. It created inefficiencies, undermined justice. It was a mess.
Were there earlier attempts to fix this?
There were. You had three significant pre-existing codices of imperial constitutions: the Gregorian, the Hermogenian, and the Theodosian.
Right, I've heard of the Theodosian Code.
Exactly. But while these were earlier attempts to organize laws, they were incomplete. And over time, they simply added to the problem, creating layers of sometimes contradictory or, just plain obsolete legislation.
So it sounds like a real administrative nightmare. And Justinian's solution wasn't just to add another layer, was it? He aimed for something truly revolutionary.
Absolutely. He wasn't just patching things up. On February 13, 528 AD, Justinian issued this powerful proclamation to the Senate in Constantinople. It's known as Const-Haec.
Const-Haec, got it.
And this was his groundbreaking blueprint for a Novus Codex, a new revolutionary code of imperial constitutions. The explicit purpose, laid right out, was to subsume and supersede all those earlier collections, along with all later imperial legislation.
Even his own recent laws.
Even his own recent laws. The ambitious idea was to replace them all with a single authoritative recompilation that would proudly bear his name. He says this pretty clearly in Const, Haec, and Const Summa.
Wow.
It was a clear declaration of a new legal era.
That's a powerful statement of imperial authority. It's more than just organization. It sounds like it's about establishing absolute clarity and unity under his reign.
Precisely. This wasn't merely an administrative task, just tidying things up. It was a profound expression of imperial will. He wanted to impose clarity and unity on a legal tradition that had become chaotic and fragmented over centuries.
A desire for order.
a fundamental desire for a coherent societal order, a singular overarching legal reality for his vast and diverse empire. You could almost say it was an attempt to restore what he saw as the true Roman order, maybe reflecting a deeper philosophical drive for cosmic and societal harmony, that kind of Voegelinian idea of establishing order in history.
Interesting lens. And to achieve something of this magnitude, he needed the absolute best people, right? Who were the architects of this monumental undertaking?
Oh, absolutely. He appointed a formidable commission. It comprised high officials and legal experts. The introductory constitutions give us a glimpse into the sheer intellectual power he assembled.
Like who? Any big names?
Yeah, you find names like John, an ex-quaestor and patrician, Beladius and Phocas, both top military commanders, Magister Militum and patricians, Basilides, an ex-praetorian prefect, also a patrician.
So top administrators.
Top administrators, exactly. Then there were the highly esteemed legal scholars like Thomas and Theophilus, both doctors of law, plus eloquent lawyers from the praetorian prefects' forum, Dioscorus and Praesentinus.
So not just scribes.
Definitely not just scribes. These were the top-tier legal minds and administrators of the empire, entrusted with reshaping its very foundations.
And what kind of authority did this dream team actually have? Because it sounds like their role was far more active than simply compiling existing laws.
You've hit on a critical point there. They were granted wide editorial powers, which was truly unprecedented for the time.
Wide editorial powers, what does that mean in practice?
Well, Haec and Const soon will clarify this. Their mandate wasn't just to gather existing laws, it was an active recreation. They were specifically instructed to cut away the irrelevant, harmonize the incongruent.
Make it consistent.
Right, and suppress the obsolete. But it went even further. They were empowered to add, alter, remove, or merge material to make the law clearer.
Wow, so they could really change things.
Well, yeah. Existing texts were to be divided up and arranged under suitable titles in chronological order. They had to remove prefaces that didn't contribute anything substantive, remove contradictory constitutions that have been annulled by a subsequent enactment, and eliminate repetitions, unless, those repetitions made a distinct legal point.
So cleaning up the clutter.
Exactly. And crucially, they were told to replenish imperfect laws. This was not mere refinement, it was a complete overhaul. It was designed to transform old law into something truly new and coherent, reflecting Justinian's vision of a perfected legal order.
So what was the immediate, tangible result of all this intensive work? Did they get it done quickly?
Surprisingly quickly, yes.
Yeah.
The initial phase culminated in the resultant codex in 12 books. It was swiftly promulgated through a letter from Justinian to Manus, the praetorian prefect of the East, dated April 7, 529 A.D.
April 529.
And it came into force just 9 days later, on April 16.
9 days. That's fast.
Incredible, isn't it? This was a complete project in itself, designed to assert Justinian's legal supremacy by creating a single, authoritative, coherent collection of laws issued over the previous 400 years, going all the way back to Emperor Hadrian.
400 years of law consolidated. That's truly ambitious. But what's fascinating, as you mentioned, is that this monumental codex was just the beginning, wasn't it?
Indeed. It sounds crazy, but it was merely a prolegomenon, basically an introduction or prelude to even grander legal reforms.
Grander. What could be grander than rewriting 400 years of law?
Well, in December 530, a new constitution, Const Deo Auctor, which we also know as C 1.1 CD.1, was issued. It was authored by Tribonian, one of the key legal minds on the commission, writing in Justinian's name, of course.
Tribonian again, he seems central.
Absolutely crucial figure. This constitution laid out a plan to, and I quote, gather together and boil down into a nutshell all the writings of the great jurists.
The jurists, like the legal commentators.
Exactly. The legal experts who had flourished from Augustus way back in 27 BCE up to Diocletian in 305 CE. Centuries of legal opinions and commentaries. The ambitious goal was to create a reduced, manageable, clear, consistent, and harmonious whole out of all that scholarly work. That became the digest, or Pandex.
Wow. So first the laws, then the expert opinions. But this wasn't exactly a calm period for Justinian, was it? Didn't he face a massive uprising that almost derailed his entire reign around then?
He did, yeah. The Nika riot, it broke out in Constantinople in January 532. It was a truly serious disturbance that almost toppled the emperor. Huge parts of the city burned down.
And yet, the legal project continued.
Remarkably, yes. This civil unrest, despite causing Tribonian to be temporarily dismissed as quaestor, likely as a political move to appease the rioters, did not derail the grand legal project. Tribonian retained control of it, maybe behind the scenes for a bit, but the work continued. It just underscores Justinian's unyielding progress and conviction.
It really speaks volumes.
It does. It speaks volumes to his deep belief in the necessity of these legal reforms.
So what does this ability to push through such a massive intellectual and administrative project, even amidst, near catastrophic civil unrest, tell us about Justinian's imperial power and his vision?
It truly underscores his formidable will, doesn't it? And his absolute conviction in the necessity of a unified legal order. This wasn't just about practical administration for him.
Right, it felt bigger than that.
It was. It reflected a powerful desire to establish a stable and coherent imperial reality, where law was the ultimate, almost sacred expression of imperial authority. From Justinian's perspective, this legal transformation wasn't just a technical fix. It was a fundamental reordering of reality, aligning human society with divine order again. That kind of effort to impose a meaningful, intelligible order on the world.
All right, let's take a moment here to just consolidate what we've learned so far. We're about 5 minutes into our deep dive, maybe a bit more. We've established Justinian's core motivation, bringing order from centuries of legal chaos through his Nervous Codex. He didn't just organize, he launched this massive project to subsume and supersede all previous laws.
Right, a clean slate almost.
He assembled a commission of legal titans, real experts with unprecedented editorial powers. They weren't just copying, they were actively cutting, harmonizing, adding, altering, even recasting legal material to fit his vision.
A total recreation.
And this initial codex, amazing as it was truly just the beginning. It paved the way for even more ambitious legal endeavors, like boiling down centuries of jurist writings into the digest. And remarkably, even the devastating Nika riots couldn't derail this mission.
It really highlights Justinian's sheer determination.
Yeah, his determination to unify the law as a reflection of a coherent, ordered cosmos. It's pretty profound.
So shall we peel back another layer now?
Yes, let's look at the legal heritage that Justinian was actually working with. What were these earlier codices he sought to supersede, and how did they kind of set the stage for his work?
Okay, so the main ones were the Gregorian, the Hermogenian, and the Theodosian codices. These were the foundational imperial collections before Justinian.
The building blocks, sort of.
Exactly.
Yeah.
They represented earlier significant attempts to organize imperial constitutions. But, as we said, over time, they contributed to the very problem of legal complexity because they were fragmented and new laws kept getting piled on top.
Right.
It's also worth noting that Justinian's Codex does contain some limited pre-Theodosian text, specifically from the late 290s and up to about 305 AD. Plus a few odd constitutions from Licinius.
Oh, interesting. So even older stuff.
Yeah, but the tricky part is, it's quite difficult for scholars today to definitively say which of these texts were originally part of the older Diocletianic codices, the Gregorian and Hermogenian. So even the foundational material was a bit of a puzzle for Justinian's team, and certainly is for us now.
And this isn't just about dusty old texts, is it? You mentioned earlier there's a vital human element in how these imperial laws were actually created. It suggests they weren't simply dictated by an emperor sitting alone in a room.
Absolutely not. That's a really important point. The significant work of scholars like Tony Enrique reminds us that imperial texts are not straightforward creations of emperors. They weren't just dictated from on high.
So who else was involved?
Well, officials and advisors played a crucial, often overlooked role in their production. Think about the Libellus or Magister Libelorum, the guys handling petitions and drafting responses between roughly 193 and 305 AD. This office included prominent jurists like Papinian, Ulpian, Modestinus, and Hermogenian.
Wow, the biggest names in Roman law.
The absolute giants of their time. Honor even suggested similar sequences of authors for the office of quaestor, another key legal official at various points in the later centuries, the 4th, 5th, and 6th.
So it was a more collaborative effort than we might initially imagine, with these legal experts deeply shaping the actual pronouncements. But was Honor's view universally accepted? Were there debates around this idea?
No, not entirely accepted, especially the specifics of his methods. There has been skepticism, particularly in North America, towards Honor's methods and his overall vision.
What were the criticisms?
Critics argued he might have underestimated the role of the general office staff and their established procedures within the palace bureaus. Maybe he over-attributed influence to individual star jurists,
Right, maybe the bureaucracy itself shaped things more.
Possibly. But even with these scholarly debates, Honor's work serves as a vital reminder. Imperial pronouncements weren't solely the emperor's creation. They were influenced by a complex bureaucratic and intellectual process.
That makes sense.
And it's also interesting, just as a side note, to observe that extensive imperial titles seldom appear outside the introductory constitutions in the codex itself. The big ones like Constic, Haec, and Constuma.
Ah, so the actual laws were more straightforward.
Generally, yes. It suggests a more functional, less grandiloquent style for the bulk of the laws themselves. Maybe a focus on practical content over imperial pomp in the everyday application of law.
Let's talk about the practicalities of harmonization then. You mentioned Justinian's commission had these unprecedented editorial powers. Can you give us maybe a real-world scenario or a specific example of how this editorial alchemy, as you called it, actually transformed existing legal material? How did they do it?
Yes, we can, and it's quite illustrative of the whole process. Remember, Justinian gave clear instructions with regard to how they were to be treated, emphasizing distribution across appropriate thematic titles to create a harmonious whole.
Okay.
The example of the Jewish slave law, which is discussed in the sources, perfectly demonstrates this active, transformative process. It shows they weren't just tidying up, they were fundamentally restructuring.
Okay. Walk us through how the specific law evolved then, through the different codices. What was the starting point?
Okay. So we begin with something called Sermondian Constitution 4. It's an almost intact letter from Emperor Constantine dating way back to 335 AD, addressed to his Praetorian prefect Felix.
Constantine, okay, what did it say?
This original law had two main points. First, it banned Jews from acquiring and circumcising Christian or other non-Jewish slaves. And critically, if such a slave was circumcised, they gained their freedom.
Right. And the second point?
The second point threatened punishment for Jews who harassed converts from Judaism to Christianity. So two related but distinct issues in one letter.
Okay, so that's the original. Now, how did the Theodosian Code handle it, the one before Justinian?
Right, so when the Theodosian commissioners got hold of this letter, they didn't just copy it verbatim. They actually divided up Constantine's single letter into two separate measures.
Ah, they split it.
Exactly. The first part, dealing with the harassment of converts, became CTH 16.8.5. The second part, focusing on the slave issue, was placed under a different title altogether, becoming CTH 16.9.1.
So even then there was editorial intervention, segmenting it, putting it under different themes.
Precisely. It showed that process of organizing and classifying was already happening.
And how did Justinian's commission handle it? Did they just use those pre-existing Theodosian passages that had already been separated?
This is where Justinian's approach gets really fascinating and shows the depth of their work. No, neither of those specific Theodosian passages was taken over directly into Justinian's codex.
Really? They ignored them?
They didn't use them as the base text? No. Instead, the Justinianic Commission looked at another law with similar content, one attributed to Constantius II, which was CTH 16.9.2. This one also forbade Jewish ownership and circumcision of Christian or other non-Jewish slaves. They then took that law and edited it into what became C 1.10.1 in Justinian's Codex.
Okay, so they chose a different primary source text even though the core content was similar? Why do that?
That's a great question, and sometimes the reasoning isn't perfectly clear. But it gets even more complex. This edited text, the one that became C 1.10.1, was then modified also from the content of two other source texts.
Wait, so they mixed and matched?
Exactly. They drew specifically from CTH 16.9.1, the Theodosian version of the original Constantine law about slaves, and also from another one, CTH 16.9.4. And here's the crucial bit. The key point present in CTH 16.9.1, but absent from CTH 16.9.2, remember the one that uses the base text.
Yeah.
That key point was that the wrongly circumcised slaves are to be granted their freedom. That specific provision was deliberately interpolated into C 1.10.1.
Interpolated, meaning they inserted it.
They inserted it right into the text derived from Constantius II's law, even though it wasn't originally there.
That's remarkable. So it really wasn't just a matter of selecting which version to include. They were actively combining elements, taking specific rules from multiple sources, and weaving them into a new composite text.
Precisely. It demonstrates a deep level of purposeful recreation, doesn't it?
It really does.
This vivid example powerfully demonstrates that Justinian's Codex was not a mere copy-paste job. The process involved abbreviation and division in earlier codices, yes, but then it went further with discarding of previous full texts and then deliberately incorporating specific crucial points into an entirely different law in the Justinianic version.
It was a profound act of editorial recreation.
Absolutely. Driven by the goal of achieving a specific, unified legal statement that aligned with Justinian's overall vision of an ordered imperial reality. This goes right to the heart of how legal systems evolve and adapt, reflecting changing imperial priorities and that ongoing quest for systematic coherence.
Okay, let's re-anchor again on the core ideas from this chapter. We're about 10 minutes in now, maybe a bit more.
Feels good.
We've covered the layers of legal history that influenced Justinian, starting with those earlier foundational Gregorian, Hermogenian, and Theodosian codices.
The building blocks.
Then we explored Tony Honore's crucial insight into the human element, the role of officials and advisors in actually making imperial law, not just the emperor dictating it.
Right, the collaborative aspect.
And we just took that fascinating deep dive into the practicalities of legal transformation using the Jewish slave law example. It showed how Justinian's commission didn't just compile, they actively abbreviated, divided, discarded, and importantly, interpolated material from multiple sources to create new, unified legal statements.
It was true legal alchemy at work.
A real recreation, not just compilation. That's a key takeaway.
Okay, so we have this monumental codex, born from such meticulous recreation. But then, as the centuries passed, what happened to it? What was its fate? There's this conventional view, isn't there, that it was essentially lost during the Dark Ages. Is that actually accurate?
Yeah, that's the story you usually hear. Lost and then dramatically rediscovered.
Right. And this is a really fascinating point of modern scholarship because it challenges that long-held myth. The conventional view for a long time was indeed that the full codex was effectively lost in the early medieval period.
What did lost mean in practice?
Well, the popular belief was that only mutilated epitomes were available. Shortened versions, often missing the Greek sections entirely. Usually the last 3 books were gone, and much of the rest was patchy. This painted a picture of a lost masterpiece rediscovered much later, almost magically, during the Renaissance.
And the Revised Understanding challenges that, right? What's the modern scholarly consensus about its accessibility during that medieval period?
Exactly. The modern scholarly consensus is quite different. It suggests the codex was never lost, even if it was not necessarily easily accessible at all times and in all places, and engagement with it was often limited.
So more like fragmented use, or maybe just parts of it were known.
Precisely. Fragmented use or partial consumption rather than complete disappearance. A key development in this change in scholarly interpretation was the redating of the Pistoia manuscript, AC 106.
The Pistoia manuscript, what's the story there?
It was previously thought to be from the 10th century, which would have fit neatly into that lost and recovered narrative. But it's now been firmly redated to the mid-11th century.
Ah, so later than they thought.
Significantly later. And this single manuscript now bears witness to a rather different story. It indicates a continuous, though perhaps limited, transmission of the text. It implies that the flame of Roman law never truly died out, even if it sometimes flickered pretty low.
So it wasn't lost, just perhaps underutilized or partially consumed in different places. But then something dramatic happened in the 11th century, right?
Yeah.
You mentioned an explosion of interest. What triggered that?
That's right. The 11th century saw a real explosion of interest in the Codex, and actually in other parts of the Justinianic corpus too, like the Digest. This wasn't just a trickle. It was a surge in legal scholarship and practical application across Europe.
What evidence do we have for that surge?
We have tangible evidence. For one thing, manuscripts of the Codex itself were directly copied for the first time in over 400 years. That's huge.
Wow, after 4 centuries.
Exactly. And furthermore, citation and quotation of the Codex in other legal texts and commentaries and in documents becomes common, even unremarkable.
So lawyers started using it again routinely.
Yes. A great example comes from the Abbey of Farfa documents in Italy. Initially, they cited the Summa Perusina, which was basically a summary of the Codex.
An epitome, like you mentioned.
Right, an epitome. But by the second half of the 11th century, the Abbey's documents were quoting the Codex directly. This marks a significant step in European legal history. It's a shift from, say, early medieval clerics just mining texts for specific theological or canonical points to a broader engagement with the complete work.
What drove that change, do you think?
It was likely driven by the needs of a more complex, emerging European society, growing trade, developing administration, the Church's own legal system becoming more sophisticated. They needed a more robust legal framework.
That makes sense. But was the Codex of this medieval era, the one being copied and cited, truly identical to Justinian's original? Or had it undergone some new transformations in its journey through time?
Oh, it definitely wasn't quite Justinian's original. There were significant textual transformations that reflected the realities and priorities of the medieval period itself.
Like what? How did it change?
Well, for instance, the Greek was abandoned. Remember, parts of Justinian's original were in Greek.
Right.
That was largely lost. Even Latin translations or paraphrases of those Greek constitutions seldom ended up in codex manuscripts. This meant a whole linguistic and cultural dimension of the original work was just gone in its medieval transmission.
What else?
Also, the subscripts with their dates were also quickly dropped. Those little notes at the end saying when and where a law was issued, gone.
So the historical context got stripped away.
Exactly. And the headings, the titles of the laws, generally became attenuated,
Yeah.
often reduced to simply imp for imperator, without specifying which emperor's name. It was simplified, streamlined for a new context that maybe cared less about precise historical detail.
Simplified and stripped down, then. Were there any additions, anything inserted that wasn't part of the original Justinianic work?
Yes, there were additions too. It wasn't just subtraction. Some limited non-codex material was also added, probably by inadvertence, being thought genuinely part of the codex.
So accidental insertions?
Yeah, mistakes happen in copying over centuries, right? Stuff gets mixed in. But then in the 12th century, you also get deliberate supplements called authenticae, which were added.
Authenticae? What were they?
These mostly derived from the Authenticum, which was a collection of Justinian's novels, his later laws issued after the Codex. The Authenticum itself only really came into widespread use around that time in the 12th century. So scholars started inserting relevant novels directly into the Codex text as commentaries or supplements.
So it wasn't a static document at all. It was a living, evolving text, constantly being adapted and supplemented for contemporary needs.
Precisely. It was a working legal tool, not just a historical artifact.
This evolution brings us neatly to Bologna. That name is just synonymous with medieval legal study, isn't it? What happened there, and what was this Mos Italicus that emerged from its schools?
Yes, Bologna is absolutely central. The 12th century saw the rapid development of formal teaching of Roman law there, and it completely transformed how the Codex was studied and disseminated across Europe.
This is where the universities start, right?
Essentially, yes. This era produced the influential glossators. These were legal commentators who meticulously annotated the texts, writing glosses, or notes, in the margins and between the lines. The most famous were the four doctors, Bulgarus, Martinus, Jacobus, and Hugo, who achieved real preeminence.
The glossators. I remember them from law school history.
The 12th and 13th centuries saw the creation of a large body of material generated by the teaching activities of Bologna, even as it formally developed into a proper university.
Was it just Bologna, though?
No, this vigorous legal writing and teaching wasn't confined only to Bologna. It occurred in other Italian cities, in France, even in England to some extent. The Justinianic material, the Codex and Digest, percolated across much of Latin Europe, even reaching places where it was previously little known. And consequently, important pre-Justinian texts that had been used locally, like the Breviary of Alaric in parts of France and Spain, largely fell into disuse. Justinian's law became the law to study.
So Bologna became the authoritative center for this rediscovered legal knowledge.
Pretty much, yes. It was Bologna that really came to provide the authoritative and standard texts and to define what the Vulgate of the Corpus Juris was. Vulgate here meaning the commonly accepted version.
Okay.
Now, there wasn't a complete monopoly of interpretation. Other schools had their views, but Bologna set the standard. Key works from this period included various summaries, or summi, often based directly on lectures given by the glossators. This culminated in the early 13th century with Azo's famous Golden Summary, which generally covered books 1 through 9 of the Codex.
Azo's Golden Summary. Right. And this leads us to the concept of the Mos Italicus. What exactly was that, and why was it so influential in shaping how Roman law was understood for centuries after?
Okay, the Mos Italicus, which just means the Italian way, or Italian method, was an incredibly influential attitude and practice. It dominated legal scholarship throughout the medieval period and well into the early modern period.
What was its core principle?
Its core principle was an intense interest in a fixed and authoritative text. They saw the Justinianic text, the Vulgate version, they established as the bedrock from which their further legal argument and exploration could progress.
Okay, but what's the key distinction from, say, how we study it now?
Here's the critical distinction. These scholars, the practitioners of the Mos Italicus, were little interested in thinking of the corpus in the light of its 6th century historical context. They weren't really concerned about how faithfully their received text represented Justinian's original.
So historical accuracy wasn't the goal?
Not the primary goal, no. They weren't trying to be historians of the law. Their aim was not to excavate the original meaning in its specific time and place. And even less were they interested in excavating behind Justinian's codification to reveal the shape of Roman law in earlier periods.
So no digging into Constantine or the jurists Justinian used?
Generally, no. Their focus was intensely practical. It was about application and developing sophisticated legal arguments from the text they had in front of them. They viewed it almost as a timeless source of universal reason and order, rather than as a historically contingent document produced in 6th century Constantinople.
That's a fundamental difference in approach.
It really is. It reflected a fundamental shift in how legal knowledge was valued and applied law as a practical science based on an authoritative text, rather than a historical inquiry.
Let's quickly re-anchor on the core ideas from this section then. We're about 15 minutes in, maybe a bit more. We've overturned that old myth of the lost codex. The reality seems to be more about limited accessibility rather than complete disappearance, with the redating of the Pistoia manuscript being key evidence.
Right. Continuous, if then, transmission.
Then we saw that dramatic 11th century renaissance of Roman law, a real surge of interest, evident in direct manuscript copying and widespread citation in legal documents.
The revival.
We learned about the textual transformations the Codex underwent during this medieval period, things like the abandonment of Greek, the loss of dates and subscripts, simplified headings, and even the addition of authenticae from the novels.
It became a different beast, textually.
And finally, we explored the profound impact of the Bologna school, its glossators like the Four Doctors, and the defining Mos Italicus. This practical approach prioritized a fixed, authoritative text for legal argument over historical accuracy or digging into the original 6th century context. Law as a tool, essentially.
And focus was on using the law, not excavating its past.
Okay, so if the medieval Mos Italicus wasn't really concerned with historical accuracy or the original text, how did we eventually get to our modern understanding of Justinian's original codex? When did that shift happen, and what did it entail?
Right, that's the next crucial phase in the Codex's long history. The significant shift towards trying to reconstruct the original codex, as Justinian intended it, really began in the 17th century.
The 1600s, so after the peak of the Mos Italicus.
Exactly. This is when the medieval codex was soon left behind, particularly with the abandonment of the Accursion gloss, that massive commentary that had dominated medieval study for centuries. Its authority started to wane.
So scholars stopped relying on the medieval commentary.
Largely, yes. The last major edition to incorporate the full Accursion gloss was Johann Fay's in 1627, which itself was based on an earlier edition by Gothofredus. After that, the Codex began to appear routinely as a single 12-book entity, again in printed editions.
So the full structure came back.
Yes, and its missing constitutions, headings, and subscripts were substantially restored in some fashion. Scholars started trying to put back the pieces that the medieval tradition had dropped or altered.
But was there a standard version yet?
No, that's the key thing. Even with this effort, no single standard codex text emerged that was as authoritative as the Bolognese Vulgate had been. There was progress, but different editors made different choices. This fragmentation meant scholars were still working with varied and sometimes incomplete or imperfectly reconstructed texts.
That sounds like progress, but still messy. It wasn't until Paul Kruger, right, that we got what we consider the cornerstone of modern scholarship on the Codex. What made his work so pivotal?
Absolutely pivotal. Paul Kruger's work is monumental and truly transformed our understanding in the late 19th century. He published his Critique des Justinianischen Codex, a critical analysis, in 1867. And then the fascicles, the installments of his two main codex editions, the Major, larger, and Minor, smaller, appeared between 1873 and 1877.
So the 1870s.
Yes. This marked a pivotal moment in the scholarly understanding of the Codex. It was a decisive move towards a critical reconstruction of its original form using modern philological methods. It was a true re-excavation of the text, aiming to get back to Justinian's time, rather than merely relying on later medieval or early modern versions.
What was Kruger's key insight? His breakthrough that allowed him to reconstruct the text so effectively. It sounds almost like detective work, piecing together ancient clues.
It really was like detective work. His key realization, his crucial insight, was that the epitome lay between the ancient codex and the medieval Vulgate.
The epitome, the summarized versions again.
Yes, those summarized or abbreviated versions that circulated the early medieval period when the full text was less accessible. Kruger understood that for much of the textbooks 1 through 9, the epitome manuscripts, or manuscripts from the very first generation of the restored codex tradition that drew heavily on the epitome, were actually the earliest witnesses we had.
Earlier than the full medieval copies.
In many cases, yes, or representing an earlier stage of the text. This was crucial because, apart from a few ancient fragments like those found in the Verona palimpsest, no manuscript of substance preserved the Codex in its full original 6th century form. Only for the final 3 books did he have to rely on somewhat later medieval manuscripts because they weren't typically included in the epitomes.
So the epitome became his bridge back in time.
Exactly. It provided a vital bridge across centuries of transmission, allowing him to get closer to the original text than previous editors had managed.
That sounds like an incredibly complex puzzle. What were the specific textual challenges Kruger faced, especially when trying to accurately pinpoint things like dates and headings? Those details are so crucial for historical context, aren't they?
Oh, immensely challenging. The basic Latin text of the individual constitutions themselves was, relatively speaking, relatively straightforward, because Kruger generally followed the readings of the best available manuscript witnesses for that core text.
Okay, so the main body of the laws was manageable.
More manageable, yes. However, the subscript attestation, that is, figuring out the original dates and places of promulgation often found at the end of constitutions, posed a completely separate issue.
Why was that so much harder?
Because the manuscript witnesses for the subscripts were incredibly few and often unreliable or contradictory. Kruger diligently printed all the known subscripts he could find, carefully specifying the manuscript or other authority auctors for each one. But here's the problem. He sometimes relies on witnesses that are not, strictly speaking, those to the Codex itself directly.
What do you mean? He used evidence from outside the Codex manuscript.
Yes, exactly. To reconstruct the dates and sometimes headings, he had to piece together information from other sources. For example, he cited the Theodosian Codex and other late antique legal sources in support of the printed text, not simply as additional witnesses, but even if they are the only evidence for a particular date or detail.
Ah, so if the only evidence for a date came from the Theodosian Code, he'd still put it in his Justinian Code edition.
Yes, often indicating the source, but it could still be misleading. This method, while necessary for attempting a full reconstruction, could lead to potential misinterpretations for the unwary reader.
Can you give an example?
Sure. Take the Constitution C, 5.4.1 examine. The date printed for this constitution in Kruger's edition derives only from the Gregorian Codex version of the text quoted at Galatio 6.4. That's a completely different earlier legal collection. And crucially, that date is not attested in any Justinian Codex manuscript that we know of.
So someone just looking at Kruger's edition might mistakenly think that date comes directly from a Justinian manuscript tradition?
Precisely. Similar problems were encountered with reconstructing the original headings of the constitutions. Given the thinness of subscript attestation, as the source puts it, versus the importance often attached to matters of dating for historical analysis, for analyzing imperial reigns and legal development, these textual issues are really critical to keep in mind when you're using even the best modern editions like Kruger's.
It highlights the interpretive work, the scholarly judgment that's inherent in reconstructing these ancient texts. It's not just a mechanical process.
Not at all. It's a constant process of evaluation and educated guesswork based on the available, often imperfect evidence.
Let's talk about some of these fascinating physical texts themselves. What are some of the key manuscripts that provide these crucial insights into the Codex, the ones that reveal its journey through time?
Yeah, there are a few standout ones, each telling a really interesting piece of the story. The Summa Perucina, S, for instance. It's not actually a manuscript of the Codex itself, not the full text.
Right, you mentioned it earlier, it's a summary.
It's a composite work marrying constitution headings to summaries. But it seems to be derived from a probably antique copy of the Codex, fortified with 7th century Latin annotations and glosses.
7th century, that's early.
Very early, which makes it a key witness to the shape and content of the original Codex, and especially to the headings of the constitutions, from a period very close to Justinian's time, even though it's not the full text.
Okay, what else?
Then we have Paris K, Beidel, nat. latitude 4537. This is a late 12th century manuscript. As it survives today, it only contains the Tres Libri, the last 3 books of the Codex, which often had a separate transmission history.
Books 10, 11, and 12.
Right. But scholars think it probably originally included the Authenticum, that collection of novels as well.
Yeah.
So it gives us a glimpse into how these different parts of Justinian's law were sometimes bound together.
And Oxford.
Oxford O, Voegelinian 3361. This is a later manuscript from the 13th century, and while it's the latest one Kruger used extensively, he chose it specifically because its constitution headings were particularly complete.
Ah, so it preserved those better than some earlier ones.
Apparently so. It also contains the Institute's Justinian's introductory textbook and the Authenticum, so it's a valuable compendium of Justinianic law from that period.
Any others that give a good visual sense?
Yes. The source mentions Avranches 141, figure 3. This is an early 12th century manuscript, and it's described as an epitome-style manuscript. Visually, it apparently features rubricated titles, titles in red ink,
Right.
headings to constitutions, but no subscripts, confirming what we said about subscripts being dropped. And it has some marginal and interlinear glosses, showing that commentary tradition in action.
Any quirks?
Apparently, there's even a strange attempt to copy Greek at the top left, which just gives you a tangible glimpse into the textual challenges and the unique characteristics these historical documents present to scholars trying to decipher them. Each manuscript really does offer a unique window into the life of this text.
Fascinating stuff. All right, let's quickly consolidate what we've just explored here. We're about 20 minutes into our deep dive.
Okay.
We've covered how the Codex was resurrected in the modern era, starting in the 17th century, shedding its heavy medieval gloss. We focus heavily on Paul Kruger's monumental critical scholarship in the late 19th century.
The game changer.
Absolutely. How he ingeniously used the epitome tradition as a bridge to reconstruct the original text more accurately than ever before. We also highlighted the significant challenges he faced, particularly with accurately dating laws and reconstructing headings, noting his necessary reliance on external sources like the Gregorian and Theodosian codices, which can sometimes mislead the unwary reader about the direct manuscript evidence.
The subscript problem.
Right. And finally, we just ran through some of the fascinating key Codex manuscripts, the Summa Parisina, Paris K, Oxford O, Avranches 141, each offering unique insights into the text's complex history, its physical form, and its transmission over the centuries.
Okay, so now for the grand finale, maybe.
Yes, let's dive into the actual substance of the Codex itself. We've talked about its creation, its journey through time, its reconstruction, but what were the foundational principles, the core ideas Justinian was trying to enshrine in his laws, especially regarding, say, divine and imperial authority? What was the point of it all, legally speaking?
This is where Justinian's vision truly coalesces and really comes alive in the text. The language used in the introductory constitutions, like const haec and consumma, is remarkably clear about this. Justinian explicitly believed his legal undertaking was mandated by divine grace.
He says that.
Oh yes, he stated he, by the grace of God, earnestly devoted ourselves to providing this universal benefit. And the goal was to eradicate entirely the obscurity that undermines correct decisions by judges. The Codex, he says, was produced to be procuturis campus, commutibus et nostro convenicit imperio. That means beneficial to the Commonwealth and fitting for his imperial authority.
So, divinely inspired and good for the empire.
That's the message. And he emphasizes the transformation. The Codex wasn't merely compiled, it was purged and rendered lucid, with all things in accord with our command, having been omitted, added, supplemented, and at times recast.
That act of recreation again.
Exactly. And this new, purified legal collection alone shall be consulted in all courts. No more digging through old contradictory stuff. This is it.
Setting down the law, literally.
Literally. And to further solidify his imperial authority, he decreed that any future laws would be issued and recorded in new constitutions, Novellae. This was a total assertion of imperial will over the entire legal landscape, past, present, and future. It positioned Justinian as the sole source of legal truth, a reflection perhaps of that unified cosmic and societal vision we talked about, law, as the embodiment of ordered reality.
And this divine mandate, this connection between imperial law and God's will, extended directly into defining and defending Orthodox Christian truth, didn't it? It seems heresy was seen not just as a religious problem, but as a fundamental legal and societal disorder. How did the law actually enforce this?
Precisely. That connection is incredibly strong in the Codex, especially in Book 1, Title 5, c. 1.5. We see this profound integration of theology and law. The legal concept of perfidia, which usually means bad faith in contracts or legal dealings, also strongly evoked wrong belief when applied to heretics.
So heresy was literally bad faith towards God and the state.
That's a good way to put it. The state actively sought to counter hereticorum intentione secundum apostolicum doctrinam, the intent of heretics according to apostolic doctrine. The Codex goes into extremely detailed theological definitions, making it undeniably clear that adherence to Orthodox Christian belief, as defined by the state-approved church councils, was a matter of imperial law, not just an ecclesiastical decree.
Can you give us an example of how specific this theological grounding was within the law itself? And what were the actual consequences for those who deviated from this legally defined orthodoxy?
Oh, it's remarkably specific. Yep. The Codex, in C1.5, meticulously defines Christ as one of the holy consubstantial Trinity, worshipped and glorified beside the Father and the Holy Spirit, consubstantial with the Father according to his divine nature, and consubstantial with us according to his human nature, capable of suffering in the flesh, but incapable of suffering as a deity.
Wow, that's straight up Nicene Creed territory, embedded in law.
Exactly. This wasn't just a doctrinal statement tucked away in a theology book. It was a legally binding truth within the emperor's code. It defined the very foundation of reality upon which the legal order was built.
And if you didn't accept that definition?
The consequences were severe and comprehensive. For instance, followers of Nestorius, who disputed this understanding of Christ, were anathematized by the Church, yes, but the Codex legally declared them alien to the Holy Catholic and Apostolic Church of God. They were even forbidden from using the name Christian, and instead were legally dubbed Simoniani, linking them to Simon Magus, a figure seen as a prototypical heretic. The law aimed to associate their crime with their very name.
Naming and shaming codified. What about practical penalties?
Major practical penalties. Heretics were explicitly excluded from holding public office like defender or father of the city, with the stated reasoning being to prevent them from abusing Orthodox Christians or bishops.
So barred from civic participation.
Yes. And there were significant financial penalties stipulated. For example, 30 pounds of gold for usurping forbidden positions. 8 pounds of gold for officials who knew someone was a heretic but let them take office anyway. And a hefty 50 pounds of gold for administrators who allowed known heretics onto their official staffs.
50 pounds of gold? That's a fortune. Where did that money go?
Straight into the divine privy purse, the emperor's personal treasury. So enforcing orthodoxy was also profitable for the state.
What about punishments beyond fines?
For free individuals, heresy could lead to banishment from Constantinople and other appropriate punishments. If they were slaves, the law prescribed the severest punishments, which could potentially even mean death, depending on the specific circumstances and type of heresy.
It's incredibly clear. The state viewed theological deviation not just as wrong belief, but as a direct threat to civil order and its own authority.
Absolutely. It reinforced its authority through ensuring spiritual conformity, backed by severe financial, social, and physical penalties. This was central to Justinian's concept of a unified, ordered empire under God.
It's abundantly clear that the state saw heresy as a direct threat to its stability. Moving on from defining orthodoxy, how did the Codex regulate the Church itself within society? How did it define the Church's privileges, its protections, and even its internal workings? It sounds like the Church was seen as an integral component of this imperial order.
Yes, very much integral, not separate. Justinian's Codex reflects profound imperial favor towards the Church, recognizing it as a crucial pillar of the stable commonwealth he envisioned. This comes through clearly in C1.2 and C1.3.
How so?
Well, Justinian deeply honored the apostolic. See, the papacy in Rome and Pope John II reciprocated this, emphasizing the belief that the peace of the Church, the unity of religion, protect its author with grateful tranquility. There's this idea of a symbiotic relationship.
Mutual back-scratching, almost.
You could see it that way, perhaps less cynically as mutual support for a shared vision of Christian order. The state sought the Church's spiritual legitimacy, and the Church benefited from the state's power and protection. There are quotes cited like, "The king rules by his lips," and "The king's heart is in the hand of God. He turneth it whithersoever he will," highlighting the divine sanction believed to underpin imperial rule.
And how did this imperial favor translate into concrete legal privileges and immunities for the Church?
In very significant ways. For example, the Codex explicitly states that privileges, which former emperors granted in general constitutions to all holy churches of the Orthodox religion, shall forever be kept valid and undiminished. Any imperial decrees, pragmatic sanctions that contradicted established ecclesiastical canons were declared void.
So church law had real teeth, protected by imperial law.
Yes. And there were major protections concerning church property. C 1.2.22 declares any alienation, selling, or giving away of immovable property or civic bread rations belonging to religious houses void unless it was absolutely indispensable for very specific reasons, like discharging debts inherited through succession, not just for normal operating costs.
So church property was strongly protected from being sold off.
Very strongly. Furthermore, religious houses were granted free legal representation. The master of the census or the city defender cannot refuse to accommodate the religious house, but must represent it free of charge, facing a steep 20-pound gold penalty if they refused.
Wow, free lawyers for the church. That's quite a privilege. What about things like inheritances left to the church?
Also heavily protected. C 1.2.23 established that inheritances, legacies, trusts, donations, or even sales intended for holy churches, hospices, poorhouses, monasteries, orphanages, foundling hospitals, elderly homes, or even cities can be claimed over a long period of time, unconstrained by any customary limitation. This period was extended to a remarkable 100 years.
100 years. That's an incredibly long statute of limitations.
Exactly. Justinian apparently wanted no time limits at all initially. This applied to all sorts of property, movable, immovable, or even self-moving property, like slaves or animals. Money left for ransoming captives also fell under this longest time rule.
That's substantial protection, reflecting how deeply integrated the church's financial well-being was with the state's vision. What about specific regulations for the clergy themselves or the church's internal affairs? Was it all privileges, or did the state regulate too?
Oh, the state definitely regulated as well. It wasn't just a hands-off approach. The Codex included clear boundaries and rules for church personnel and operations. For instance, the ordination of a crypticii. These were unfreed tenants bound to the land.
Serfs, basically.
Sort of, yes. Their ordination was declared of no substance unless the manifest consent of the owners is obtained. The owners retained their property rights over them as if no ordination had taken place. This shows the law trying to balance the church's spiritual role with existing societal structures and property rights.
What about actual slaves becoming clergy?
That was utterly forbidden, according to C 1.3. Slaves could not join the communities of the clergy, even if their owners willingly consent, unless the owners first gave them their freedom. This underscores the legal requirement of free status for holding spiritual office.
So clear rules about who could become clergy. What about how clergy interacted with the secular legal system?
Also regulated. The Codex states that all clergymen shall answer to the rulings of viri clarissimi provincial governors without any distinction of privilege, provided they fell under that governor's jurisdiction. This applied to bishops, priests, deacons, monks, regardless of their status within the church hierarchy. They weren't above the provincial law in ordinary matters.
So no complete immunity from secular courts.
Not for ordinary civil or criminal matters under the governor's purview. However, cases concerning the state of the church itself, internal disputes, doctrinal issues had to be brought only before the most reverend bishops or metropolitans or before the holy synods or most reverend patriarchs. Civil cases between parties could optionally be heard by a bishop if both parties agreed, but no one against his will could be compelled to use a bishop as a judge instead of a regular court.
Interesting jurisdictional lines. Did bishops have any role in overseeing secular officials?
Yes, quite significantly.
Yes.
C 1.4.26 gives bishops a vital role in overseeing secular administration. Bishops currently in office were explicitly instructed to report to us, the emperor, any negligence that they should observe on the part of the viri illusters, sectabiles, and clarissimi magistrates, or on the part of the official staffs.
So bishops were acting as imperial watchdogs over the governors.
In a way, yes. And the metropolitans, the bishops overseeing provinces, were responsible for ensuring the provincial bishops actually did this observation and reporting. It highlights how profoundly public life and law in the Byzantine Empire were intertwined with spiritual observance. Bishops weren't just religious figures. They were integral to maintaining administrative probity and the overall health of the state. It was a truly holistic vision of an ordered Christian society.
Now let's broaden out from the church to the state itself. How did Justinian's Codex go about administering justice and defining rights for the Roman state as a whole? Let's focus maybe on the fundamental principles rather than trying to cover every single law, which would be impossible.
Right. The Codex obviously delves into incredibly intricate details of judicial structure, personnel, and procedures. But if we look for underlying principles, a key one is the pursuit of accountability and clear process throughout the system.
Accountability for whom?
For officials, primarily. For example, it established mechanisms for high-ranking Palatine officials, like the Count of the Sacred Largesses, to report directly to the emperor about the negligence of provincial judges. This demonstrates a clear hierarchy and a push for oversight from the center.
What about keeping different branches of government in their lanes, like military versus civilian?
Yes, that was another important principle, a key rule stated clearly. Custody or enforcement in the suits of private citizens may never be delegated to soldiers. This aimed to maintain a distinction between military and civil authority and prevent potential abuses of power by the army in everyday legal matters.
Okay, that makes sense. What about the judicial process itself? Were there core principles aimed at ensuring fair procedure for litigants?
Absolutely. The Codex clearly aimed for a fair and predictable judicial process. A fundamental principle we see repeated is the idea of finality. For example, C 2.3.4 states that no logic permits a case once closed to be revived after a party has formally renounced their suit. Lawful settlements were also binding and couldn't just be reopened by imperial whim. This established stability and finality in legal decisions.
What about ensuring honesty in the process?
That was a major concern, addressed partly through the crucial role of oaths in litigation, which we find in C 2.58. To prevent perjury and ensure judges and parties took things seriously, arbitration and litigation processes required sworn oaths.
Oaths from whom?
Pretty much everyone involved. Litigants had to confirm their choice of arbiter under oath. The arbiters swore to settle the dispute truthfully. The plaintiff had to swear they weren't bringing the suit vexatiously, but genuinely believed they had a good case. The defendant had to swear their defense was based on a good faith position.
Even the lawyers.
Even the learned advocates had to take an oath, with the Holy Gospels present. And, importantly, judges were explicitly instructed to in no way permit waiver of such an oath, but by every means demand it from the plaintiff and the defendant. This wasn't seen as optional. It was for the common benefit, pro communit utilitati, emphasizing a deep concern for truth and moral integrity within the legal process itself.
So a strong emphasis on truth-telling, backed by a religious sanction.
Exactly. It was seen as vital for maintaining an ordered and just society.
It sounds like the Codex was very attentive to ensuring the integrity of the judicial system. What about protections for potentially vulnerable groups? You mentioned minors earlier. Or even basic rights like self-defense.
Yes, the Codex definitely shows a clear concern for the vulnerable. Minors, those under the age of 25, received significant legal protections. They were often granted the benefit of restoration of rights, restitutio in integrum, in cases where they were significantly harmed by a legal transaction, especially concerning sales of pledged property or contracts that didn't actually enrich them.
So a way to undo bad deals made when young.
Essentially, yes. While there are some limitations, for instance, the manumission, freeing of a slave by a minor, generally couldn't be rescinded later just based on age. The overall thrust was definitely to shield young people from exploitation or the consequences of youthful indiscretion in legal matters.
And self-defense, was that codified?
Yes, quite explicitly in C 3.27.1, individuals were granted free permission to resist attackers, specifically mentioning night marauders or ambushers on frequented roads. The law stated such offenders were to be immediately subjected to punishment and could essentially receive the death they threatened.
So a right to use lethal force in self-defense.
In those specific dangerous circumstances, yes. The guiding principle stated in the law was, it is better to prevent in time than to avenge after the outcome. It reflects a pragmatic approach to immediate threats to public order and personal safety.
Okay, that's clear. What about fundamental areas like property and inheritance? Were there key principles there aimed at ensuring fairness or stability, particularly within families?
Indeed. Family and property were central concerns. The concept of the undutiful will, querela in officiosi testamenti, found in C 3.28, is a prime example.
The undutiful will, what was that?
It addressed situations where close family members, children, sometimes parents, were unjustly disinherited or left only a tiny portion of the estate by a testator. A complaint could be brought to set aside the father's will, or mother's in some cases, as undutiful if the testator left less than a legally defined minimum, typically a fourth part of the property that he had at the time of his death, to those entitled heirs.
So you couldn't just cut your kids off completely without a very good reason?
Not easily, no. This ensured a fundamental right to a certain portion of the inheritance for close family members, reflecting the Roman emphasis on familial continuity and the proper transfer of property within the established social order. There were exceptions and complexities, of course, but the basic principle was strong.
What about dividing property held in common?
There, too, the law aimed for clarity and fairness. For common property, like an inheritance shared by multiple heirs, the principle was that no one is compelled to be trapped into holding communal property or participating in a partnership indefinitely. C 3.37.5. Any co-owner could demand a division, and the governor would oversee it. This prevented people from being stuck in unwanted co-ownership and facilitated clear individual property rights.
Just putting it all together.
Putting it all together, whether dealing with the highest matters of religious faith and heresy, the intricate privileges and regulations of the church, the detailed mechanics of the justice system, or the fundamental rights concerning individuals, family, and property, the Codex of Justinian consistently aimed to establish a comprehensive, coherent legal framework. It was designed to underpin a stable and well-ordered Roman state.
The complete system.
A complete system, yes. It was a profound articulation of Justinian's vision of society as a divinely sanctioned order, reflecting that deep philosophical quest for a coherent reality manifested in law.
That was an incredible dive into the spirit and the letter of Justinian's laws. It really covered the waterfront, the spiritual foundations, the civil structures, the administrative procedures, all aimed at this vision of order for the Roman state. It truly highlights just how comprehensive the Codex was intended to be.
It really was an attempt to define the world through law.
So if we were to boil all of that down, maybe into a kind of flashcard list for our listeners, what would be the absolute must-know takeaways from this massive body of law we've just touched upon?
Okay, let's try a quick summary of the key legal principles embedded in the Codex. First, Justinian's Novus Codex itself. Remember, the driving goal: reduce complexity, replace all old codices with one single, clear, authoritative collection that reflected his unified vision of law and empire.
Got it. The one code to rule them all.
Second, unprecedented editorial power. His commission wasn't just compiling. They were actively reshaping the law, cutting, harmonizing, adding, altering, recasting, a true recreation.
More than just copy editors.
Third, theological foundation of law. This is huge. Heresy wasn't just wrong belief. It was legally defined as bad faith, a disorder threatening the state. Orthodox belief, especially regarding the Trinity, was legally enforced with severe penalties.
Like exclusion from office, massive fine.
Yeah, heresy penalties. Exclusion from office, fines sometimes reaching 38 or even 50 pounds of gold, banishment, even potentially death for slaves. Spiritual conformity was a legal requirement.
Okay.
Fourth, the church as a pillar of state. The church received extensive privileges, think property alienation being void, that 100-year claim period for pious bequests, free legal representation.
But it was also regulated, right?
Exactly. Clergy regulation. Strict rules on who could be ordained. For example, unfree tenants needed consent, slaves had to be freed first, and clergy generally had to answer to provincial governors and secular courts. Bishops even had a role overseeing magistrates. It shows the church was part of the system, not above it. Fifth, fair judicial process. The Codex emphasized clear procedures. Think about imperial rescripts, trumping continuances, specific judicial holidays being observed, but crucially, the mandatory use of oaths to ensure truthfulness.
Oaths in litigation. Required for the common benefit, not something you could just waive.
Right. And contumacy. If a defendant just didn't show up, there were real consequences. Default judgment, the plaintiff could be put in possession of property. You couldn't just ignore the court.
Accountability.
Sixth, protection of vulnerable and rights. We saw significant protections for minors under 25 through the restoration of rights, although with limitations, and the explicit right to self-defense against immediate violent threats.
Basic protections.
Seventh, inheritance and property rights. Key concepts like the undutiful will complaint ensured close family weren't totally disinherited without cause, requiring at least 14 of the property. And rules facilitated the division of property held in common, promoting clarity.
Protecting family lines and property.
And finally, maybe tying back to the process, pacts and agreements, stress on good faith. Naked pacts generally didn't create obligations alone, needing delivery or formal stipulation. And once a case was lawfully settled or closed, it wasn't supposed to be revived. Finality was key.
That covers a huge amount of ground. It really paints a picture of a legal system trying to comprehensively order society. Hashtag tag outro.
Absolutely. As we wrap up this deep dive, it's just profoundly clear, isn't it? Justinian's monumental legal undertaking, the Codex, was driven by this relentless, almost obsessive pursuit of order, clarity, and stability. It wasn't just across law, but across every conceivable aspect of society.
Yeah, it really wasn't merely a collection of rules. It feels more like a philosophical statement, an attempt to define the nature of reality and human existence through law, reflecting that deep desire for cosmic order to be mirrored in human society.
It wasn't just about organizing old scrolls. It was about creating a coherent, understood reality for an entire empire. from its highest spiritual beliefs down to the most minute details of private property ownership or courtroom procedure.
And when you think about it, the Roman Empire's desire, embodied here by Justinian, to codify, purify, standardize its laws, including its incredibly detailed regulation of religious belief and the nuances of private life. Doesn't it reflect a deep-seated, maybe even universal human need for a coherent, understood reality, a world where truth and order are clearly defined?
That's a powerful thought. And this ancient imperial project, this drive for comprehensive order, it definitely resonates even today, doesn't it? You see echoes in modern attempts to create comprehensive legal frameworks, or even in societal debates about defining social order truth.
It does, and it raises that important question you touched on. What are the enduring challenges, or maybe even the potential pitfalls, when a state seeks to establish such a singular authoritative truth, when it claims its legal code embodies a kind of perfected comprehensive order?
Exactly. Consider that delicate balance. It's always a tension, isn't it?
Hmm.
The balance between imposing that kind of comprehensive top-down order and preserving individual liberty, individual conscience, maybe even just the messiness of real life.
That tension seems ever present in large-scale legislative efforts, even ones as grand and historically impactful as Justinian's Codex. It really makes you wonder how much our own modern pursuits of order in law and society are still echoing this ancient, deep-seated imperial drive.
It's definitely a thought worth mulling over long after this deep dive ends. A question about the nature of law and power itself.
We certainly hope this journey into the complex world of the Codex of Justinian has given you, our listeners, an entirely new perspective on the foundations of Western law and the enduring, complex legacy of one of history's most ambitious legal minds.
Absolutely. Until next time, keep exploring the depths of knowledge.